Hello, everyone. My name is Travis Pantine. I'm the director of the Insurance Law Center here at the University of Connecticut School of Law. And I'm very happy to welcome you to a new semester of the Insurance Law Workshop that I'm co-hosting with my wonderful colleague, Peter Siegelman. So for those of you who are joining us for the first time, welcome. As background, what we're aiming to do here is draw in a diversity of thinkers from various disciplines to talk about insurance law extremely broadly construed. Our attendees are generally a mix of academics, especially law professors, but other types of academics as well, students, including many of our own JD and insurance law LLM students, and regulators and practicing lawyers. And if you don't fit into one of those buckets, that's still great. A few notes on format. So presentations will generally be about 30 to 45 minutes long, leaving about 30 to 15 minutes for Q&A from the audience. When we open it up for Q&A, Peter or I will keep a queue, so you can use the little raise hand button, or you can send a message to us in the chat if you'd like to ask a question. The sessions will be recorded and posted to our website. The readings are also posted to our website, and we encourage you to check them out ahead of time. This workshop will be held at the same time this fall and for the foreseeable future. So if you'd like, you can hold a spot on your calendar on Thursday afternoons. And another thing is you can also now subscribe to our calendar. If you go on, if you click through in the email announcements, and that'll pre-populate your calendar with the relevant WebEx links and other details. So with all that, now I'm very happy to introduce you to today's speaker, who probably doesn't need an introduction, Professor Mark Geistfeld. Professor Geistfeld is the Sheila Lubetsky Birnbaum Professor of Civil Litigation at NYU Law, where he teaches and writes about torts, products, liability, and insurance. And he's also the reporter for the ALI's new Principles of Civil Liability for Artificial Intelligence, a very exciting project. So today he's going to be sharing with us a draft of a paper about how liability issues that are raised by AI stand to fundamentally disrupt standard principles of tort theory. Which would seem to suggest that the right way to think about AI risks is just to impose a framework of strict liability and then move on. It's a super interesting paper with lots of cool ideas, and I look forward to hosting a very interesting Q&A after Professor Geistfeld gives his presentation. So with that, Professor Geistfeld.
Thanks for having me. I look forward to hearing your comments. This is a paper. It's in a lot of ways it's about mainstream tort theory. So it's but I think last semester there was a paper by my colleague Kathy Sharkey and Ken Abraham at Virginia talking about there being a glaring gap in tort theory about its failure to adequately account for liability insurance. And so this is certainly in kind of that. I agree with their conclusion. I think there's a massive failure to adequately think about insurance in theorizing about liability rules and formulating them. I think Kathy and Ken don't adequately emphasize, like most mainstream scholars, that costs that are associated with the insurance question. And so a lot of this paper is about the costs of using liability insurance to compensate injuries. It's something that I've been emphasizing my entire career. I got the way I have a PhD in economics, and my dissertation was about this issue. I got into torts, products liability insurance, by way of this particular issue, and have relied on it, used it in various iterations early on. It never really got traction, certainly within the law and economics community. And outside of the law and economics community, there seems to be this idea that we don't need to think about insurance in general. It's just a funding mechanism for injuries. It's not interesting to the liability questions. So there's plenty of other stuff to talk about. There's lots of interesting things in the tort world to address. And so I moved on to other issues. And what happened as the AI technologies have come out, particularly it started with autonomous vehicles. There was a wave of proposals for strict liability for the crash of an autonomous vehicle. And then another flood of proposals for strict liability as applied to AI-caused harms, the large language models, generative AI, ChatGPT, DeepSeek is the one all over the place now. But these models, similarly, the idea, we know they're going to cause harms, and there's a lot of people who say, it ought to be strict liability. And all of these proposals basically rely on the mainstream theory that I had been criticizing for quite some time. And so I can fully understand how, if you're not deep in the weeds on the theory, you're not a theorist who is working out with formal economic models how this stuff works. If you just read the literature and use the models, well, you're going to end up with the conclusion that strict liability is a no-brainer in the AI space. And interestingly, the arguments here, as formal as the economic models have gotten, there's just a very fundamental, basic way in which it draws on the logic of workers' compensation schemes. And interestingly, if you look at Steve Chevel's early paper on strict liability versus negligence, which is one of the standout papers in this literature, at the very end, he acknowledges that, yeah, this is kind of what enterprise liability theorists were talking about a century ago. I've just generalized it, formalized it, and added, of course, a few other considerations. But the basic logic has been there all along. And the logic of the argument, you can see in the context of workers' compensation and AI, it just is a natural extension. The argument for strict liability is twofold. If we look at it from a deterrence perspective, the difficulty with negligence is that it's extraordinarily difficult to prove systemic kind of harms in the workplace. Most workplace injuries were attributable to the design of the workplace. It wasn't the failure to cover up a hole or the use of a shoddy ladder or something like that. It was the design of the mine and things like that. And it's extraordinarily difficult, if not impossible, for an injured worker to show that the mine should have been redesigned in a way that would have reduced the risk of injury and it would have prevented my particular injury. And so workers were not recovering under negligence liability for that and related reasons. And so there was a widespread understanding that strict liability would shift the safety decision onto the employer, and just minimizing costs would induce the employer to make the workplace safer. And then strict liability would compensate workers for their injuries, a further bonus. So we would further both injury and compensation in ways that are very desirable from a tort perspective. And that's exactly what the states did when they enacted workers' compensation schemes. It's progressive reform. Employers should be paying for these as a cost of doing business. It's fair, it's efficient, provides injury compensation. It's a win-win-win. And I don't disagree with any of that as applied to the issue of workers' compensation. The difficulty is that basic logic, it gets built into economic models that then are applied to a different type of problem. And when you shift it into the space of AI-caused harms and other kinds of harms outside of the workplace setting, it turns out that the mainstream theory of strict liability here rests on two assumptions that are untenable. Because as it's commonly understood, it straightforwardly applies to AI-caused harms, which is why you see so many proposals advocating for strict enterprise liability for the commercial distributors of AI technologies. The so-called black box problem of AI. We know the mathematics, how they're structured. There's coders putting these algorithms together. We know how they're put together. We just have no idea of why they produce the outputs that they do. You cannot reverse engineer a decision of these complex algorithms. To put it most simply, the neurons within a neural net, the little nodes in each layer, each node does not stand for a particular concept. It's not like the neuron number 5 in layer 82 is the one that identifies the leg of a pedestrian if you're using AI to do image capturing for an autonomous vehicle. There's way too many concepts, even for billions of neurons, which is what some of these large models have, there are way too many concepts relative to the number of neurons to fully capture the complexity of the information. And so the best understanding of what goes on is that actually the AI itself creates its own kind of AI within itself, a superpositional strategy in n-dimensional space to fully capture the concepts in question. So obviously you can't reverse engineer that. So that's the simple description of the black box. We know the output, and we know the output is what the algorithm deems to be the best, most likely right output given the inputs that it's had and so on. But again, we have no idea why that output is produced. And that's the black box. So it would seem like if we don't know why it makes a decision, then how could we possibly prove fault? How could we possibly prove defect-based products liability? The black box is inscrutable. All we can do is look at the output of the algorithm. And if the output is one of injury, so the only verifiable output is injury or no injury, that's what strict liability is all about. We need strict liability. And hey, you know what? Strict liability works for all the reasons that workers' compensation and the mainstream theory of enterprise liability says it does. Let's throw the safety problem onto the commercial developers of these algorithms. To minimize their liability costs, they're going to figure out how to design these algorithms in a way that's going to minimize the social cost of accidents. And then we're going to be compensating the victims of these technologies. So we have a win-win-win. And then, you know, once you're sophisticated in insurance, so you know how we have the added bonus of once we get the liability insurers involved in the mix, they have risk management expertise and so on. And so the insurance as governance literature kicks in at this point and shows how liability insurers can help to manage this complex problem and make the world an even safer place. And so there's there's no apparent downside to the use of strict enterprise liability, aside from the pesky problem of policyholder moral hazard. You know, we all know that yes, insurance is going to dilute the policyholders' incentives to exercise care, the problem of moral hazard. But the liability insurers, like any other insurer, they can manage that. They've got contractual devices. They've got the kind of risk management practices I was talking about. They've got plenty of ways to deal with the problem of policyholder moral hazard. So, you know, just kind of bracket that pesky problem aside, and there's nothing that says that there's any downside whatsoever to strict liability as applied to AI technologies. Now, within the mainstream model more generally, the other form of moral hazard that you would worry about is that, you know, if a driver, for example, of a regular car is strictly liable, and the pedestrian is fully compensated for all injuries, then the pedestrian has a form of moral hazard. I incur no cost in the event of a crash, assuming I'm fully compensated. So why would I exercise care in order to keep myself from getting hit by a car? And so then you have things like contributory negligence and so on, which help to ameliorate the problem. But basically, what goes on within the economic model is once you start to rely on negligence in any kind of way, you have to recognize that negligence always depends on proof. And so the basic, the simplest way to understand the logic of the conventional economic model is that if you define an activity as any component of risky behavior that's not adequately regulated by negligence due to problems of proof, then by definition, strict negligence can't get to it because problems of proof can't regulate that component of risky behavior. So the only way then to regulate an activity is to use a rule of strict liability. So for example, tort system to this day is never going to question whether you should get in a car and drive from Hartford to New York City, even if it's on a whim. Doesn't matter. No court is going to say, was that worth it in light of the risk that you created while getting in the car? The activity of driving is not regulated by negligence liability. There it's not so much necessarily problem of proof, it's just a judicial policy decision that we're not going to ask that question. And so if we want to regulate the activity of driving, we want to make sure individuals drive the optimal amount of miles, we got to subject drivers to strict liability. Because then you, the driver, are going to think about, if I drive to New York City, I'm going to crash. I got to pay for that. Is it worth it for me in light of the costs, et cetera, et cetera? Yes, you have insurance, but again, the liability insurer can manage the problem of moral hazard adequately to deal with that activity level problem. And so the basic choice then within the standard economic model is if it's important to regulate the activity of the injurer, the driver, then we're going to make strict liability for the driver. And if it's important to regulate the activity levels of the victim, the pedestrian, then we're going to shift the injury costs onto the pedestrian. And we'll have rules of negligence like contributory negligence embedded in there. But again, activity is the component of the risky behavior that falls outside of the negligence liability due to problems of proof. So as applied to AI technologies, you can see how this just straightforwardly leads to strict liability. The activity that we're worried about is the black box problem. The ability of users to affect the riskiness, yeah, we're worried about the third-party bad actors creating bioweapons and so on. So there's that kind of risk, which is why we want to make these models safe. But in terms of, who can control the risk, and is that risk one that we would deem to be an activity rather than a risk that's controllable by negligence? It's pretty clear that the activity of creating an AI technology and putting it out into the marketplace is the one we worry about. And so make the commercial distributors strictly liable. They will solve the safety problem. They'll have liability insurers help them out, and the victims of injury get compensated. And it all draws on the progressive reform of workers' compensation. So it just seems like a great idea in the same way that workers' compensation was great. And so there's just a ton of articles that essentially adopt that. And they'll go into details about why problems are proof and difficult and so on. But that's a basic logic of a wide swath of proposals for liability with respect to AI-caused harms. And so having read all of those, it's like, it's really time to knock down what I think are two massively important assumptions that are wrong within mainstream theory, and it's time to call them out because they are leading to these proposals that I think are both under-theorized and ultimately badly mistaken in this context. So the difficulty in the first instance of extending workers' compensation logic to something like AI-caused harms is that workers' compensation occurs in a very distinctive type of setting. It's a contractual setting, but it's also a contractual setting in which the individuals exposed to the risk are supposed to be compensated for facing the risk. If you take on a job, you will demand, if you're well informed, compensation for facing work-related risks. That's a cost of the job, just like giving up your time is a cost of the job. And so markets, when they work well, compensate workers for facing risks. All right, now the market problem workers' comp addresses is that workers don't really know the risks that they face. So they don't demand an adequate amount of compensation. And so as a consequence, there's a compensatory problem that exists due to this market failure. Workers, moreover, couldn't adequately regulate product safety by way of negligence actions due to the difficulty of proving fault. So strict liability there solves both problems quite nicely. You're compensating workers after the fact by way of liability insurance, and you're freeing them from the obligation to prove fault to create the right incentives. All right, now you move outside of the workers' comp setting to AI-caused harms, think of the consumers. And the AI technologies here are very helpful because these are general purpose technologies. They're very much going to be very much like electricity and things like that. It's going to be a fourth industrial revolution. It is going to widely proliferate across society due to the general purpose nature of this technology. It's widely recognized. The ways in which this is going to impact our lives, just completely difficult to identify right now, aside from the fact that it's going to be very general and pervasive. And so what that means is that we're all going to be users in the same way that we're all users of electricity, whether we're paying for the cost of electricity directly because it's my Con Ed bill that's covering these lights right here, or indirectly when I go to the grocery store across the street, I'm paying for the electricity in the store by way of higher prices at the store and so on. We're all paying for something like electricity, and we're all going to ultimately be paying for AI services. All right, so now in that context, when the providers of electricity or the providers of AI technologies get hit with liability, that's a cost of performing the contract. And as is true of any other cost of performing a contract, it gets built into the contract price. And so we pay by way of higher prices for the liabilities that are incurred by the duty bearers. So when we then think about the compensatory problem, it's fundamentally different from workers' comp. Workers deserve to be compensated, and if you want to compensate them after the fact with liability insurance, that's great. Much better than having them demand increases in their wages and so on due to the market problems I was describing earlier. When individuals are paying for their entitlement to compensation, that's exactly what we do when we buy insurance. We just called it an entitlement to indemnification rather than compensation. But to say that I'm being compensated when I'm paying for it just misdescribes the problem. And courts recognize this quite widely with the move to products liability. The manufacturer is going to build in a price increase to cover its liability costs. And in effect, that increase in price that consumers pay is the premium that they're charged in order to get an entitlement to compensation in the event they're injured. It functions as a form of insurance. And then the manufacturer spreads that in the risk across all consumers. You have the risk spreading properties, et cetera, et cetera. So isn't all that great? It can be great, but it depends on what are the alternatives. All right, now, once you start to think, when products liability first develops and it's drawing on the workers' compensation schemes, this is going on in the 1940s. In that era, health insurance was not widely available. Health insurance is pretty much a byproduct of World War II. The social insurance programs that are now available, that's a product of the Great Depression. So in the first part of the 20th century, if you're thinking about, does it make sense for a consumer to get insurance through the manufacturer by way of liability insurance? The question is, as compared to what? As compared to no insurance? Without question, having some insurance through the liability system is much better than getting injured and having to bear those injury costs on their own. So if you compare the insurance mechanism of no insurance versus tort insurance wins, and that's an argument for strict liability. So products liability starts down that path, reasoning in this manner. And then what happens over time, of course, is we get a robust growth of health insurance, social insurance programs, and so on. So today, the choice is not between no insurance and liability or tort insurance. It is between first-party insurance and third-party liability insurance. All right, now mainstream theory accounts for that. It recognizes it, but not adequately so. There's this idea that, look, it's going to be either it's going to be liability insurance or it's going to be first-party insurance covering an injury. Because we know from the principle of indemnity that the injured party is not going to get double compensation. You can't recover from the liability insurer and then recover for the same injury from the health insurer. Only one of them is paying. So it's either first-party insurance or it's third-party insurance. And then when I started doing this, I was saying, hey, you know what? There's still a cost differential there. Third-party insurance is more costly for lots of reasons. Most simply, you got to hire a lawyer to get that compensation. And usually for health insurance, we don't have to hire a lawyer. But for those of us who teach insurance law, it's like, sometimes you do, and you need to understand insurance law so you can understand how to litigate those cases. But as a general proposition, you just submit your medical bills and you get compensated, indemnified, much less than what you think you should be. But that's a regulatory problem in the health insurance space. But Third-party insurance is more expensive than first-party insurance. So all else being equal, in other words, if the deterrence properties of different regimes were all the same, and you just looked at the insurance dimension, and the right holder is paying for the insurance, either by way of higher prices through the tort system, or I'm paying the premium directly to a first-party insurer. When you frame it that way, yeah, it is more expensive to compensate injuries in the tort system. And so if all else is equal, we would reduce costs by not having tort liability, because again, I'm assuming the risk levels are the same, whether it's liability or not liability. We're just looking at the insurance problem. We wouldn't use tort to compensate injuries. We would use first-party insurance mechanisms. And the mainstream theory, it says, yeah, we're choosing between the two, but it's either liability insurance or first-party insurance. And yeah, there might be this little cost differential, but not so much, nothing to worry about. So you see this issue mentioned in passing, but it's never been given the prominence that I think the issue deserves, in part because I think the issue is much, much more fundamental than what I have depicted in the past, what others have depicted in the past. And I'll try to explain why I think it's a lot more of a severe problem of insurability or relative cost than what has been previously recognized. The other mistake that mainstream theory makes is it assumes that the tort system chooses between either negligence liability or strict liability. And you could again look to workers' comp to see this. Workers' comp just knocks out negligence altogether. We just have a regime of strict liability. Now, even if we don't have a statutory scheme that does so as a formal matter, as a practical matter, strict liability seems to subsume all negligence actions. Because what is the obligation that one owes in the event of acting negligently? Well, it's an obligation to pay compensatory damages. Isn't that the same thing that you face under strict liability? So what's the difference between the two? Put somewhat differently, if I have a right to compensation under a rule of strict liability, why would I ever litigate a negligence claim? So we might have negligence on the books, but as a practical matter, it's going to be rendered irrelevant. So basically, courts are required to choose between negligence or strict liability. You couldn't have a mixed regime because the negligence rule would just be rendered practically irrelevant. Now, both of those assumptions, they seem unremarkable on their face with that little slight twist about the slight cost differential between first-party insurance and third-party insurance that I was alluding to. Aside from that, they seem to be fairly unremarkable assumptions. And again, then you take that model and you apply it to AI-caused harms. It seems to lead to a very powerful argument for strict enterprise liability. Any commercial distributor should be strictly liable for the harms that these technologies cause, and it has all those desirable compensatory and deterrence properties that I was just describing. All right, now if we just start, I'll just quickly move through the deterrence problem because this is an insurance workshop, so I'll spend more time on the insurance part of this argument than I do in other contexts where I have tort folks interested in the deterrence side. The deterrence problem ends up being one that at first glance, a lot of sort of people who really know the economic model are surprised by, because there's just this overwhelming belief that strict liability just has such superior deterrence properties that it's hard to really buy into an argument that it's somehow lacking outside of this technical problem with activity levels of pedestrians and things like that. The problem, the mainstream theory just misses what tort law actually does. And what tort law actually does is it layers strict liability on top of negligence, and it does so for very good reasons. And negligence is not irrelevant for reasons that I'll briefly describe, but in fact is quite a robust liability rule. If we just had a pure regime of strict liability has no obligation, it imposes no obligation on the duty bearer aside from the obligation to pay compensatory damages. All right, so what that means then is if we think about the safety decisions involving AI technologies, we're talking about potential existential threats. This is big stuff, this is worrisome stuff. You got governments around the world freaking out about this for good reason. A rule of strict liability says you do whatever you want, Silicon Valley, just pay for the injuries. All right, so it turns what is an existential safety decision into a complete profit maximization problem for corporate actors. All right, now you might still say, well, aside from the problem of bankruptcy, which admittedly is huge, just look at what Purdue did. You can get away with a lot of wrongdoing, and people can profit from it, by relying on the bankruptcy scheme. So there's bankruptcy is widely recognized to throw a wrench into this argument, but it's still not deemed to be problematic. The difficulty with the conventional economic model is it assumes that compensatory damages fully compensate the injury in question. So that when you're paying compensatory damages, you are in fact paying the full social cost of the injuries in question. And that's flatly wrong as a matter of basic tort law. And the most easy instance to illustrate that is just the case of wrongful death. Wrongful death, you cannot compensate a decedent for the loss of life's pleasures. Wrongful death damages are shockingly low in relation to other kinds of harms. There's one study that was done in New York City jury verdicts back in the 90s. A herniated disc gets about 50% of what a wrongful death claim gets on average in New York City juries. Not like a herniated disc is half as bad as wrongful death, but that's just the way the damage measures work. There's a long-running recognition within tort law that bodily injuries are irreparable harms. An irreparable harm is one that cannot be adequately compensated by the monetary damages remedy. And so what you do with compensatory damages is you do the best that you can do to compensate the injury in question, but there's no, outside of pure economic, financial harms, where a dollar fully replaces a dollar. These are irreparable injuries under the common law definition. Now, in the same way that the common law deals with irreparable harms in injunctive area, if you show there's an irreparable injury that's threatened, and you can show that an injunction would not impose undue hardship on the other actor, you can get an injunction to shut that activity down. And courts will say over and over in that context, better prevent the irreparable harm than trying to compensate it with inadequate damages after the fact. All right, so the claim in the deterrence part, it's a longer tort argument and so on, is that the best way to understand negligence liability is it's not a property rule, it's not a liability rule within conventional mainstream theory, it's a behavioral rule. It obligates you to try to exercise reasonable care, and it's formulated in a way that's done to try to prevent the irreparable harm of premature death, bodily injuries, and so on without imposing undue hardship on the duty bearer. And the exercise of reasonable care is an effort to figure out what would be a fair burden to impose on risky actors. And you can still work it out with cost-benefit analysis and so on, but that's a whole long tort argument that's beside the point for present purposes. But the key thing is that monetary damages don't adequately compensate irreparable injuries. So a regime of strict liability with nothing else would not adequately deter the injuries of the most grave concern to the tort system, irreparable harms. So we're going to fully commercialize the safety decision with a monetary damages remedy that can't adequately compensate for wrongful death, severe injuries, and so on. So there's a big, huge deterrence problem that exists there. And this is all independent of the problem of bankruptcy. So as a consequence, the tort system uses the default rule of negligence liability, and it supplements it with a rule of strict liability. Now, in modern practice, products liability cases routinely contain claims of both negligence and strict liability. And you talk to trial attorneys and they'll tell you the reason why you litigate a negligence claim is that it makes relevant the defendant's conduct. If you're doing a pure claim of strict liability, as I said, there's no behavioral obligation, so you have no basis to get in any evidence concerning the defendant's conduct. So that's what attorneys call a cold case. It's just the product injured somebody, there's compensation that's owed and so on. You'll get recovery, but it's a cold case. If you could show the manufacturer was acting unsafely, that is a hot case, because now what you're doing is you're showing there's a deterrence problem here. This isn't just about injury compensation. This is bad conduct that we want to deter through the imposition of liability. So there's empirical studies showing that actually juries will award higher damages for the identical injury when it's litigated as a negligence case than as a strict liability case. And of course, you're not doing it for something like lost wages. It's in the pain and suffering domain, where juries have a lot of discretion in figuring out what fair compensation is. So the size of the damages award importantly depends on whether you're litigating the behavior at all. So strict liability does not render negligence irrelevant in the way the mainstream theory presumes. Also, if I know that now we're all negligent pretty regularly, and most of the time when we drive cars, we all act unreasonably at some point, if not pretty regularly during the trip, because we're not automatons. But fortunately, most of our negligent inadvertence doesn't cause a crash, and so we're not usually liable in negligence for having hurt somebody. But it's a very demanding rule. So most instances of negligence don't involve somebody who's blowing off their obligation and saying, hey, it's cheaper to pay compensatory damages than it would be for me to exercise reasonable care. The economic model, the mainstream model, assumes that, hey, if it's too burdensome for me to exercise reasonable care, I blow that obligation off and I just pay compensatory damages. It's just a rule of strict liability. All right, mainstream doctrine, there's case after case in which courts will say, hey, you know what, if a manufacturer knows the product is defective and decides to commercially distribute that defective product, we're not going to let them just pay compensatory damages as a cost of doing business. We're going to hammer them with punitives. That's the point of punitives, is to prevent this kind of activity from happening. So you can't consciously disregard the obligation to exercise reasonable care. You might breach it inadvertently, and we're not going to hit you with punitives, but it is a behavioral rule. You have to exercise good faith efforts to trying to comply with a very demanding standard of reasonable care. And if you fail to do so, analogize it to bad faith liability, you're going to be hit with punitive damages, rightly so, because we want to prevent the injury in the first instance. We don't want to compensate it after the fact with monetary damages. So you're going to then, any plausible regime of strict liability, and even as a political matter, we're not going to just come up with a rule that says, hey, Silicon Valley, do what you want. Just do some profit maximizing in the boardroom there and write some checks for all the injuries that might be caused by these technologies. That's not politically viable, but it's also not defensible in principle. We want there to be behavioral obligations. We want them to be trying to act in reasonably safe ways. And so you're not going to displace negligence liability. You're going to build strict liability on top of negligence. And so what that means, if you're just thinking in terms of litigation costs, strict liability is necessarily going to increase litigation costs. It's necessarily going to increase premiums for liability insurance, because you're not wholly displacing negligence and substituting more cases that can be litigated on a less costly basis. You're adding a bunch of new cases that wouldn't otherwise exist, but you still got that baseline rule of negligence. So you've got basically the costs of the negligence regime with the added costs of the new cases in a regime of strict liability. So you're increasing litigation costs, and that in turn, of course, is going to affect the costs that liability insurers have to cover by way of legal defense and so on. So you're increasing the cost of liability insurance that, by the way, is being paid by, ultimately, at the end of the day, by consumers, because we're paying for that in the form of higher prices and the like. So strict liability is not going to eliminate the need to look at negligence and try to figure out what are reasonably safe performance standards for AI technologies or any other kind of technology. Now, when we move to the insurance problem, the focus of the group here, the mistake that is made in this context is the assumption is, again, is that it's either third-party liability insurance that compensates the injury, or it's first-party insurance. And yes, okay, there might be a cost differential between the two of them, and that's the only worrisome problem of insurability or relative cost that we need to think about in this context. All right, the mistake there is it assumes that when individuals make insurance decisions in the first-party markets, that they do so by reference to their tort entitlements. And you look at the basic logic of first-party insurance, why first-party policies bundle risks in the way that they do and so on. First-party policies for health insurance, by and large, again, outside of things like moral hazard, adverse selection, and well-known insurance problems, you're not bundling risks based on the cause of the loss. Whether I need health insurance because I broke my leg skiing or whether I fell on the street or whatever, from my perspective, I need to have my medical expenses covered. So for me to have to buy a policy covering my injuries on the street and another policy covering my injuries while skiing and yet another while I'm using power tools and on and on and on, you can see how the transaction cost of that kind of granular scheme would make no sense. So when the risks are correlated for a policyholder in the sense they're correlated in the sense that they all result in medical expenses, you reduce transaction costs for the policyholder by bundling all those risks into health insurance. And yes, again, sometimes cause matters if there's an undue problem, moral hazard, and adverse selection, and so on. But aside from that, your health policy is covering a wide range of risks, independent of the cause in question. All right, now, how would then the ability to get recovery from a strictly liable manufacturer of an autonomous vehicle for my injuries, how is that going to affect your health insurance decision? You're not going to say all of a sudden like, oh, I don't need health insurance because if I'm in a car crash, the manufacturer is paying for my injuries. You still need health insurance because obviously there's plenty of reasons why you incur medical expenses outside of car crashes. And even when you can recover from the health insurer, from the manufacturer and tort insurance, you still need health insurance. And here the bad faith cases involving first-party insurance are really, they give great fact patterns on all of this. If you don't have health insurance, you're the ordinary person without health insurance, good luck getting good health care. And so you need health care in the first instance, health insurance in the first instance, and really in order to gain robust access to the medical system these days. Now, you might get tort compensation down the line, and then we'll have subrogation actions and so on. But even the right to tort compensation does not eliminate the need for health insurance. So individuals make their decisions about first-party insurance. Government social insurance programs are set up. They're not based on the cause of loss in question, it's the type of loss. And again, when I say it's not based on the cause of loss, it's because I'm ruling out things like moral hazard and so on. All right, now when we think about liability insurance, of course, it is pinned to the cause of loss because that's the source of the manufacturer, the policyholder's legal liabilities. So it's all about causation, requires inquiries into causation, they're costly. And it's that inquiry into causation coupled with legal defense costs that largely, or legal costs that largely explains why third-party insurance is more costly than first-party insurance. Just that costly inquiry into causation, the need for legal representation, neither of which usually exists for first-party health insurance, disability insurance, social insurance programs, and the like. All right, but that cost differential doesn't adequately capture the full costs of strict enterprise liability. So let's say that it would cost $1.25 to compensate $1 of injury cost, giving the 25% loading factor fee to the insurer there. And that if we then shift to liability insurance, due to the inquiry into causation and the need for legal representation, the costs rise to $1.50. All right, so the shift to strict liability from a regime of negligence, which in the absence of fault means that the victim is paying for the injuries by way of first-party insurance and the like, is going to increase the cost of injury compensation by 25 cents. You go from $1.25 to $1.50. All right, that's something, but it actually understates the costs of shifting to strict liability, because once you recognize that individuals are making their insurance decisions independently from their tort entitlements, it's not either liability insurance or health insurance. It is that we're layering liability insurance on top of health insurance. So we're duplicative coverage here. It's not one displacing the other. We ultimately displace it by way of subrogation actions and the like, which are quite expensive. But notice how the subrogation action ends up impacting the right holder, the consumer who ends up paying for this one way or the other. You're paying for the first party premium, or you're paying for the liability insurance by way of higher prices. All the subrogation action does is just shifts the injury cost between the two insurers. But from the perspective of you, the right holder, it's not doing you any good other than the way in which the shifting of costs might have some impact on the relative premiums, but it's extremely costly for the insurers to engage in these subrogation actions. Again, stuff you study in insurance class, what do you do with compromise settlements, et cetera, et cetera. So it's not like subrogation is a costless action for shifting injury costs in a way to prevent duplicative coverage. It just further drives up the transaction costs of compensation created by duplicative insurance without creating an added insurance benefit. So once you recognize that there's duplicative insurance going on, then going back to my earlier example, $1.25 under health insurance, $1.50 under liability insurance, you move to strict enterprise liability. If liability insurance is layered on top of first party insurance, for the right holder, the consumers who are paying for this, their insurance cost is now $1.75 per dollar of injury compensation. So the shift to strict enterprise liability has increased their cost by 50 cents, not the 25 cents as in that example before. A much more substantial increase in insurance costs than prior analyses have recognized. And the key thing out of all of this is that, yes, workers' compensation does provide valuable injury compensation for workers who are supposed to be compensated for job-related risks. And if we compensate them with liability insurance, that's great. But when you're talking about right holders who pay for the entitlement to compensation, what we're doing with liability insurance now is we're not actually compensating them in a cost-effective way. We're duplicating insurance for them. And then when you work through the properties, the insurance properties of tort damages, it basically turns out, of course, for economic harms, that's a standard insurable kind of loss. Non-monetary injuries, pain and suffering, it's always been contestable. Is that an insurable loss or not? And there's good arguments on both sides of the aisle. I don't think there's a strong argument that says purely for insurance purposes, individuals want to spend money to get financial compensation for what is by definition a non-financial harm. It turns on technical things like how the injury affects your marginal utility of wealth and so on. There's lots of literature out there saying individuals adapt to harms they suffer so that their welfare over time actually kind of equalizes. I don't think that justifies the elimination of these damages, but it just goes to the question of, do you really want to buy insurance covering pain and suffering, things like that? Probably not. Doesn't mean pain and suffering damages aren't valuable for tort plaintiffs from an insurance perspective. And it has long been recognized, if you're thinking about this from an insurance perspective, what tort damages for pain and suffering actually does, it provides legal insurance for plaintiffs. So if I lose, the contingency fee lawyer is the one who's covering the cost. So I'm covered in that event if I'm a plaintiff. But if I win, my contingency fee lawyer takes out 30 to 50%. That's a financial loss for me. That's not insurable. You can't get insurance for plaintiffs' legal costs out there in the marketplace. There's some limited forms, but it's not a robust market. And so you can understand tort damages for pain and suffering. And again, this is not a unique or an argument that I've come up with. It's been recognized by many others before. You can understand the logic of tort damages for pain and suffering is basically compensating the plaintiff for legal costs of litigating the claim that's not otherwise insurable. And so then what you end up with here, when you think about liability insurance, as it affects the way we think about a liability rule, it's completely different from the workers' comp setup. Workers' comp, again, it's fair compensation that solves a market failure problem in a good way that promotes deterrence. And note also in the workers' comp context, we have OSHA, we've got regulations that are making sure the workplace is adequately safe. We're not just relying on employers with, trying to minimize their liability costs in a regime of strict liability. We wouldn't have a robust, whether it's robustly enforced is a separate question, I grant that. But we wouldn't even contemplate a robust regulatory regime of OSHA and the like if we thought that strict liability adequately solved the workplace safety problem. So there's lots of differences about workplace safety that don't exist in the AI space. We get into consumers paying for the tort compensation. Liability insurance is now not a form of compensation for them. It's basically a form of duplicative insurance, massively increases their insurance costs because it duplicates, by and large, first-party coverage or coverages that are available under social insurance programs. So I think the right way to conceptualize liability insurance in this context is it's essentially the transaction costs that consumers have to pay in order to litigate their claims in the tort system. And there's value to litigating tort claims in the tort system. So liability, I'm not like dumping on liability insurance, like liability insurance is a bad thing. It's just not properly understood as a good form of injury compensation for consumers who pay for their entitlement to compensation. Instead, it's best understood as allowing a negligence regime to function in a robust way. It funds, it smooths, it reduces the costs of liability for the commercial policyholders. We bring in the liability insurers to manage risk. All of those are good properties. And it funds the legal costs of plaintiffs in litigating their claims. So there's lots of desirable properties to liability insurance, but it most certainly is not about injury compensation. All right, so then now you think about the move to strict liability for AI-caused harms quite differently. Now it's like we're expanding liability massively. So we're expanding the transaction costs associated with tort liability massively. All right, now whether the transaction cost is worth it depends on what we're getting in exchange for it. If it's not injury compensation, of course it has to be deterrence. The reason for litigating these claims, the reason for the liability rule is to create the financial incentives for these commercial actors to act safely. So it's all a question of, are the added costs of insurance worth the deterrence benefits that you get by way of expansions of liability? So there's an insurance deterrence trade-off that's endemic in the formulation of these liability rules, and it has the pesky problem of policyholder moral hazard and the activity levels of pedestrians and so on. Yeah, it matters, but it is a distant concern relative to the insurability deterrence trade-off that I'm describing right now. And what I do in the last piece of the paper, it goes more heavily into AI technologies and just points out that this idea that the black box that I started with, that somehow it forecloses negligence liability, that just really does not adequately understand the nature of the tort problem for important forms of liability. If you look at autonomous vehicles and you look at forms of medical devices, where basically if you look at cyber physical systems, in which you've got the AI causing a physical system like a medical device or a vehicle to operate out there in the world, that in those instances, what we really, the right way to measure the safety performance is not on a case-by-case basis. Why did the Waymo robo-taxi crash when it made a left turn up there? That's not the way to think. It's a system. There's one operating system. It's as if there is a single driver operating all of the Waymo robo-taxis in San Francisco. And to evaluate the safe behavior of the Waymo robo-taxi, you need to ask yourself, how does it perform across that entire domain? So it could, in fact, not be in any accidents except for one accident that would most obviously be avoided by a human driver. But to focus on that single accident and say, therefore, it's a defective operating system, it's unreasonably dangerous, misses all of the accidents that a human driver would have caused due to inattention, drunk driving, everything else that happens out there in the world, massive safety benefit to the technology that you completely gloss over if you just focus on the isolated instance of a crash. So the importance of evaluating safety, same again is true for medical devices, is by way of system-wide safety performance metrics, which don't require you to look into the black box. It's just how many crashes was the AV involved in over 100 million miles or whatever. These are hard questions. We need regulatory help and so on, for sure,
Mark,
but they're conceptually valid.
I'm
Yeah.
going to jump in where most folks will turn into a pumpkin in 3 minutes, and
Okay.
if you want to leave some time for Q&A,
Oh, I'm
we can
sorry. Okay. I thought
stay
we were
over for a
going
little bit
till,
longer, but I mean, it's
I was thinking we were
really
going till
tough.
6. I'm sorry. Okay.
No problem.
Yeah. Keep going. Open it up.
Well, anyway, so incidentally, that really speaks to how good it can be to have a person present this kind of thing without PowerPoint, because that was a really great example of just verbal exposition. So anyway, for folks who have to leave at 5, you're free to take off, especially the students, but maybe we'll stick around a little bit longer for questions. So I'll open up the queue. And if you do have a question, let's ask it concisely if you can. Peter, and then Dan.
Yeah, I mean, I would be happy to sit here and talk about this for another 4 or 5 hours, but I think other people, including you, probably have other things to do. So I've got a zillion questions. Let me just, you started to answer the last one. Let me just ask you about existential risks, though.
Yeah.
I mean, is tort liability even remotely the right way to think about the problem of existential risks, like negligence or strict liability? Yeah, but I mean, if you're going to blow up the world, it seems like the tort system is not going to do any of us any good, because when that accident occurs, there won't be any tort system or any world.
Yeah.
So no one's going to really be taking that into account.
Yeah, exactly.
It seems like there's some deeper problem here.
Yeah, no, that's absolutely correct. And so a much longer answer is required here, but the idea here is that, yeah, obviously you need regulation here. Well, tort might help here. I think injunctive relief is going to become way more important in this space for exactly the reason you described. So you can have tort obligations. You can have an actor that looks like clearly blowing off those obligations. What you just described is the irreparable harm of all time. And so injunctive relief, I think, is going to, you got to, stop doing what you're doing until you clean your act up. That kind of remedy is going to become much more in play than it has been in the past. But the other answer there is that tort has worked through what reasonable safety is and what ought to be done. Now, whether we end up then having that be utilized by regulators and so on to inform the way that they regulate these technologies would be a very good strategy here. Rather than regulators figuring this out on their own, tort system has been wrestling with these problems for centuries. And so I think there's a lot of institutional complementarity that you could draw on there, because if you're just relying on the monetary damages remedy and nothing else, then you're absolutely right. So it's another way of understanding how the clearly strict enterprise liability for existential risks, that's no answer whatsoever. And it's also true that negligence liability for existential risks, but negligence does let you get to the injunctive relief, and it does have performance standards that could really help shape regulatory strategy. Because right now, the discussions in the AI space are, let's be responsible. There's very little understanding of what reasonable safety is all about. So there's a great deal, I think, of information that could be conveyed to the tech industry and others about what reasonably safe behavior actually involves. So maybe if we don't implement it in the tort system, we can still shape the regulatory approach by letting them know how tort system solves these problems.
Great, thank you.
Great. Dan Schwartz.
Hi, this was really fascinating and interesting. I also have a zillion questions, and I also, like Peter, would love to hang out and talk more about this, which is great because we'll have you at UConn in a few months to be able to do that. But I guess my specific question that I want to press on now involves an issue that I don't think you talked about, which is a sort of pretty well recognized benefit of strict liability over negligence is that you invest over time in developing new safety standards. And so negligence, in a sense, is based a lot on custom, is based a lot on sort of regulatory standards, it's based a lot on sort of our current cost benefit analysis. But if we don't think that's the right way to judge whether or not we want to change the behavior of a manufacturer, strict liability has a lot of advantages because it forces firms to adapt beyond the sort of present standard of care. And just like concretize this a bit more, I want to use a very specific example that you used. Let's imagine that you have Waymo and that you can show very clearly that the Waymo cars are way safer than human drivers.
Yeah.
But let's also imagine that 1 out of every 10,000 times, it just randomly hits people who are wearing red fuzzy sweaters or whatever.
Yeah.
And one analysis could be, well, there's no negligence because relative to the baseline, you're taking due care.
Yeah.
But on the other hand, we would want to incentivize Waymo to figure out a way to it's not clear that you would get that with negligence. So how do you think about that in your model?
Yeah, so you need, so you're identifying this is, this technology is continually improving in theory. So you need to have adequately adaptive regulations. And the same is true of the negligence rule. So the way that you get it in the Waymo context there is there's also, manufacturers have a duty to warn about inherent product risks. So even if the design of the vehicle is not defective because it satisfies the benchmark, which over time the benchmark is going to change, but not in the incremental dynamic way that strict liability would have. But you can get that same dynamic safety incentives created by the duty to warn because manufacturers have to warn about the inherent risk. So it would be very easy for NHTSA, or you could get this by way of the tort obligation, or the federal regulators could impose this regulation on it. Let's say that the whatever the standard is, if it turns out that the manufacturer needs to disclose the inherent risk of crash, it might be that all I am is I meet the safety standard. I've just met the benchmark in the way that you've described. And so all you do, your sticker on the vehicle says, meets federally mandated standards. Now, if my competitor is twice as safe, then you have a sticker that says 2x times safer than mandated safety standards. Now that gives me an incentive to ratchet mine up to 2x, or I'd like to go to 3x or 4x. And so the duty to warn is actually disclosing the inherent risk of crash. And if you disclose that risk to consumers in an easily digestible form of the type that I'm describing here, just like we get with miles per gallon on the stickers of new vehicles, something like that, where you just look at it and you go, that was 4x safer and that one over there is 2x safer. So I know which one is safer by actually a fair amount, by a pretty wide margin. You're going to get that same dynamic safety incentive. There's similarly, you can have post-sale obligations to update the operating system wirelessly, as is already occurring with autonomous vehicles. But for sure, you're right that when you're doing this, you need to be quite cognizant of the dynamic nature of it, so that any negligence-like rule has got to be adaptive over time, so it continually incentivizes the actors to seek to continually improve these products rather than just rest on some kind of outdated standard that's been long eclipsed in theory by the technology, but they're just staying behind because the law is enforcing them in that direction. There's other things you can play around with in this space. You could use the most forward-looking, if you're talking about the large language models, generative AI, you can look at, there's lots of civil actors out there who are trying to figure out the right thing. You might, as compared to ordinary negligence liability, look at the safest practices out there and let the plaintiff satisfy the burden of proof by relying on the safest standard, and then force any manufacturer or distributor that's not doing what is most safely possible out there right now to explain why it's not doing so. And obviously that's not going to play well with the jury. There's lots of liability risks. So you can continually promote or encourage more and more robust safety measures with, again, presumably the good actors out there behind this in part. But you can also see how, as a competitive strategy, it might not be a bad idea if I can figure out a way to do something and my competitors can't. I can end up foisting a lot of liability on them in a way that's going to incentivize them to figure out these problems.
So I'm going to put myself on the queue with this may be a kind of wacky question and maybe not theoretically interesting, but I'm going to ask it anyway. So my understanding of these of AI right now is that much of it is funded by by private capital like SoftBank and stuff like that. And so and all these companies like ChatGPT or OpenAI and stuff, they're losing a ton of money. And I wonder whether that changes the analysis at all. If there's something different about the nature of capital and the nature of this industry that so if the people who are paying for AI right now have a really inelastic demand to invest in speculative development of AI, does that change the impact of the transaction costs, right? Does it make for a smaller loss in consumer surplus if the transaction costs go up? Like more casually, like if the people who are going to be bearing those transaction costs don't care, if the Saudi sovereign wealth fund is just going to shovel money into AI regardless, does that change the analysis at all?
Well, that you're assuming there that the model that's produced by the Saudi fund or whoever we're talking about is then freely available. And that's certainly true for some kinds of AI stuff. You can, there's free versions, but they're usually the weakest versions of those models. And you have to pay a subscription to get the powerful models. And by and large, the powerful models are the kind of harms I've talked about. Of course, AI causes like a ton of different kinds of harms. And so I'm really in the ALI project that I'm working on. We're focusing in the first instance on the core problems, bodily injury, property damage, and so on. We can't do copyright. We can't do reputational loss, the deep fake stuff. All of those are important harms for sure, but we can't solve all that in one fell swoop. So we're starting with the most worrisome problems, the kind of core tort problems, and we'll expand out over time. So when you focus on that set of problems, where you're really worried about powerful models that can be used for hacking. For example, I can now use this system to figure out how to hack into other computer systems and so on. I use it to figure out how to make a bioweapon or something like that. Then it's the powerful models, like I said, that you really worry about. And those generally aren't free. But you are right. If they are in fact given freely out there in the marketplace, then it's certainly, at least the way that I'm analyzing it in terms of the right holders are paying for the liability here, that drops out. It's not to say that we wouldn't end up with a different, there's a stronger argument for strict liability in that space, but you're still going to need the negligence baseline for reasons I discussed before, because we're just not going to want to give this safety decision entirely to those commercial actors.
Great. So we have a question from Mark Mayerson. Mark, do you want to jump in? I think you're on mute.
Yeah, Mark, you're muted.
He still can't hear you.
No, you're definitely muted.
Take your time. This will be the last question, probably. Great.
Okay, sorry, it defaulted to the wrong microphone. First of all, you ruined my day because I had allocated some time this morning to glance through the paper, and it was so amazingly compelling and interesting that I ended up devoting 3 times my allocated share time today to it. So thank you so much for it. But I just wanted to follow up with your Waymo example.
Mm-hmm.
And you didn't, I don't know if you didn't quite finish the point. So the person who's injured, do they get compensated? And you're saying, well, maybe Waymo's acting reasonably and
Right.
non-negligently, so they
Right.
should not be. So the next logic would be, okay, we should have a fund for compensation for victims like that. And then once we take that sentence, we're in workers' comp land. Um, what do you think should happen to the victim of that Waymo left turn who
Right.
was non-negligent on a system-wide basis?
Yeah. So I think actually in the developmental phase, when these vehicles are out there right now on the streets and they're learning how to drive at our expense, I think the right analogy there is the National Vaccine Act. We're exposed to risk, but there's a public good that follows from it, and so compensation seems to be a fair way of mediating this particular problem. I'm on board with that. Once they're widely commercially distributed, then again, the question is, so yes, it's right, they're not going to get tort compensation, but they do have first-party mechanism insurance available to them. There are social insurance programs, and there's a long part of the, not a long part, but there's a section in the paper where it's like, look, it is true that individuals do not have, not everybody has insurance, not everybody's covered by social insurance programs. And so then the question would be, at least for tort purposes, you've moved outside of tort, so you're in a different space here. So I'll grant you that. But my point, the limited point, is that for tort purposes, it doesn't follow that, well, let's use strict liability as a way to compensate those who are uninsured right now. That's not the right solution. You're absolutely right that maybe a victims compensation fund, for if there are enough of these crashes, that becomes a social insurance program. That would be a defensible way of doing it. That is completely complementary to everything I'm talking about here. It's just that my point is just that the idea that you're going to use strict liability as the injury compensation mechanism, that's misguided here.
Well, okay. So I completely agree with what Mark Meyerson just said. I spent the whole morning reading this and I felt exactly the same way. So thank you so much for all of that, for the fabulous talk and the great paper. And you're presumably available if people want to reach out by email and stuff like that?
Yeah, no, I'm glad. It's very helpful for me, obviously, to understand how people are interacting with the paper. And so, yeah, so for those of you who are spending a lot more time on this, all I can say is the same is true for me. It's like it's one of those projects I thought I'd knock off, and I find myself as I'm still revising this puppy here. So, but it's been a fun project to work on. So I hope that you all find it to be fun in its own way as well.
Wonderful. Thank you again. And let me just say that on May 30th, the Insurance Law Center is sponsoring a whole conference, a whole day on AI and insurance. And Mark will be back for that, but there'll be other interesting panelists as well. Thanks, and see you all in 2 weeks. Thank you, Mark, very much. I have comments for you too that I'll send.
Yeah, thanks again for having me.
Okay, bye. Bye, everybody.
Take care.